Good evening, everyone, and welcome to our February Writes at Night. I am Lisa Morgan. I'm a kindergarten teacher and currently president of GIE. I'd like to thank you for joining us this evening. And our session this evening is about something that seems to happen earlier and earlier every year. So that's why we scheduled it for February. Because we do have people at districts, it seems, that want to issue contracts early and earlier, and we want you to have all the information you need when that happens. So our presenter this evening is Mike McGonigal, GAE's General Counsel and Director of Legal Services. And I will turn it over to him to provide the information. If you have a question as we're going along, put the question in the chat, and we will try to make sure we get all your questions answered before the end of the evening. So Mike, thank you very much.
Thanks, Lisa. Good evening, everybody. My screen's visible?
Yes.
Okay, great. Progress. So we're gonna have about 20 or so slides we want to go through and look at some of the legalities and mechanics and nuts and bolts of your contract and what it means, and deal with some scenarios as to how to get out of your contracts. That seems to be like one of the main questions that we will be looking at this spring. But I wanted to, there's a few, I always add these housekeeping and preliminaries just to emphasize everybody on the meeting tonight's a member, but this is a good reminder as to when you meet a potential member, somebody who's not a member, what the legal program here through NEA and GAE provides. And you can see the liability. I mean, it provides liability insurance in the event that, say, a parent on behalf of a special needs child is alleging the district did not provide them with free appropriate public education, and is definitely there. But we really don't have that many lawsuits, believe it or not. And I know that that's a fear that everyone has if you're sued, but that's really not where the meat and potatoes is with legal services. It really comes through the vast majority of our cases are under our employment and certification defense. And no other organization has or we are the only organization that does not have a predetermined cap on the amount of legal fees and costs that we expend in defense of a member who might be up for non-renewal or termination. Or we also file affirmative lawsuits against school districts in appropriate cases. We received a very good court order today from a judge in Charlton County. That's on the near the Georgia coast, southeast Georgia, on the Florida border. And the judge found that the district is deliberately ignoring and covering up systemic racism in that school district. And they've been doing this for decades and decades. And so the judge found in our favor and was requiring the school district to disclose emails and text messages that relate to our member, Dr. Cheryl Green, who applied to be superintendent there. And so that's a huge, huge win. And just so you know, the costs in this case are they're already over a limit that other organizations have, and that's not an issue with us. The issue with us is doing what's right and filing these cases when we know that we can prevail, and we're prevailing so far with a great win on Charlton County on behalf of GA member Dr. Cheryl Green, and I'll have more on that in our newsletter that's going to come out in March. So one other, just moment, I just want folks to reflect. It's become important for me in the association in 2018, 2019, and ending up in 2020, when GAE looked at its own legacy issue in our Constitution and bylaws that had certain language in it, which was referred to as ethnic minority guarantee. And we updated that language to a more contemporary commitment to diversity and inclusion at all levels of GAE. But I think it's important for us as an organization to really remember, who we are and what our values are, and where we came from is instrumental in us moving forward as an association. And it comes, at a time you can't get more complicated or more education more under attack as we are now, when we have all these culture wars going on right now. But GA is the only organization that is the product of a merger, and the merger is premised upon the core American ideal that everybody is created equal, and we're equal. And I want folks to just remind themselves that the merger, which occurred in 1970, it was just not a one-off event that happened 50 some years ago, but those values are who we are today. And those values of equality and democracy and inclusion of all people serve us very well as we move into the future. So I just wanted to pause and let people reflect on our core values, who we are as an organization. So as we're wading into the area, when I do legal presentations, tonight it's about teacher contracts or contracts. You always have to start and remind folks and continue to educate members that many of the rights that were fought for by that new organization in the 70s and onward up till very recently, they've been waived. The state of Georgia has allowed school districts to waive many of your rights that have fought for and people struggle to get into state law can be waived. So one of the things that we always need to keep reminding ourselves is whether it's a contract or duty-free lunch or certification requirements, state salary schedule, whenever those questions come up, you need to look at your your school district. You need to check into your policy and see what type of school district you are working for. And the chances are everybody on this call is either employed by a strategic waiver school system or a charter school system. There's little difference between the two in that they both can waive any law that they choose under Title 20. Strategic waiver is a little different in that they get to pick and choose which of Title 20 laws they can waive. A charter school system like Atlanta, for example, has a blanket waiver where all of Title 20's education laws, with a few exceptions, are waived. And the grand idea behind this concept is if you waive the onerous, laws from the backs of the school district, student achievement will increase. So, by eliminating rules, school achievement, student achievement will increase. Well, but that's not proven whatsoever. And that's the basic premise of the law. Has not been demonstrated. There is no evidence to show that student achievement and student test scores have increased as a result of waivers. And I don't have it in this presentation. But the Georgia Department of Audits conducted an audit of strategic waivers and charter school systems in Georgia and looked at the question, and they said there's just no evidence to support that waiving education laws and your rights as educators has any, much less causal connection, but there's no correlation between waivers and student achievement. So there's, the emperor has no clothes. And I know that with President Morgan has been engaging on an education campaign and will continue to do so. And within the next couple of years, if we have some change at the State House, we might see some real progress in reinstituting the laws that had been waived. So I thought one way to start wading into teacher contracts, I thought, well, what isn't a contract? Well, I found it interesting in preparing for other talks that Georgia's at-will employment doctrine was decided back before the Civil War. There was a case in 1853 where a plantation overseer sued the plantation owner to recover wages. And the Supreme Court of Georgia there said that, well, because it wasn't in writing and the contract was not for a definite term, then either party could terminate the employment relationship, but there was no contract. And so that's the sort of it's the origin, the recorded origin in law of the at-will employment doctrine, or what isn't a contract in Georgia law. And then it was codified, that particular ruling was codified in 1947 during Jim Crow. 34-7-1 codifies Georgia's at-will employment doctrine. And that came, and there's a lot of those laws that were passed during Jim Crow right around that time as a way to essentially keep Black employees in their place, as well as to, as a part of other statutes, to oppress the development of unions here in Georgia. There's a separate doctrine that we don't have time to get into, but those were adopted in the 1940s here in Georgia, and they're still good law, still on the books. And just lastly, there's a good, for those who have extra reading time, you should pick up this article by Professor Ballum that discusses the true origins of the at-will employment doctrine here in Georgia. And it's a real good discussion of pre-Civil War South and the labor movement, what either Blacks were subject to or poor whites were subject to here in Georgia, and the way the law developed to not expand those rights for either of those segments of our society. So, and there that goes, little resuscitation. So let me move this out of the way. So what is a contract? We just went over what isn't a contract. So what's a contract? And there's basic common law elements. Common law is judicially, created law. Like in that previous slide, we saw 1853 decision. That's an example of common law, which was then codified in the 1940s in Title 34. As you see, the basic elements of a contract they're universal. Everywhere you go in the country, you have to have an offer. There has to be acceptance, and there has to be consideration. And so we'll go through and ask some questions. Well, what's a valid offer? What's valid acceptance? and what's valid consideration. And then also a contract, in order to be a contract, it has to be enforceable. So what happens when one party breaches the contract? You take them to court, and a court has to be able to enforce the mutual promises contained in the contract. And as you see, the common law elements are then codified in Title 13. And that's where you can go and look up a lot of the common basic elements of contracts in Georgia. Where are we? Okay, well, it's not advancing now, so let me. Okay. It's slide's not advancing. Let me see. Oh, there we go. I have to have something drop in. So, okay, so the basic education law statute 20-2-211 governs educator contracts. You can look that up. What's a valid offer? Well, thankfully, the statute says that a letter of intent is not a valid offer or a valid contract. GA had that language put in years ago, convincing the legislature that you can avoid a lot of litigation by clarifying in the statute what a lot of districts were trying to pull the wool under your eyes. That this time of year, there's a form that goes around saying, is it your intent to return to the school district next year? Yes or no? What do you want to do? And school districts would say, well, you checked that you were returning to the school district on this form, and that's a contract. And, we said, no, it's not, and eventually got the statute amended to say pretty much the obvious. That's not a valid offer, and that's not a valid contract. Also keep in mind that you have, at least if it hasn't been waived by your school district, a statutory 10 days to renew your contract, or excuse me, review it before you sign it. And I always recommend, take the full 10 days, just because it's your right, and you shouldn't be bullied into signing the contract. Or if the secretary says, Mike, come up to my office today, sign your contract, and you'll be good to go. Well, if I look at the local board policy and see I've got 10 days, I'm going to exercise my right, because that's one of those things that I have a right to. And I just think it's important not only know what my rights are, but to exercise them. And I might pick it up and with every intent of signing it, but I want the district to know that I'm an informed educator, and I'm going to exercise my right.
Exhale now.
It's not advancing for some reason. Let's see if I can. Well, I apologize. My screen is frozen. I don't know why. Well, maybe that was it. I don't know
That
why.
was, yeah, that'll go.
I I like those resuscitating somebody who's dying because our rights have been taken away. That I find that little graphic to be kind of funny. But so we know, an offer really is when the written agreement is tendered to you. It could be by the secretary, or you could get a memo or email, say, hey, they're in your box, you're in your mailbox, go get them. Some districts offer the agreement by email, by electronic means. But that's the valid offer, is the actual, the document, 2 pages, but that's the offer. And that's when your review period begins, not before. So now acceptance is a couple things. One is, it's usually your contracts are already pre-signed by the superintendent, and then it requires your signature. But the contract isn't binding until the Board of Education votes on it. And that can work, that's a two-sided coin. If the board hasn't voted on a contract and you want to get out of it, well, you've got a good case to say, oh, the board hasn't created a binding, valid agreement because they haven't voted on it. And it can also be useful when somebody tenders a resignation, and without coming to us first, and they go, oh my God, I resigned. Can I rescind my resignation? And usually the answer is yes, you can, because it takes time for the resignation to present it to the Board of Education. It's usually they will get in a line with other matters scheduled for the next board meeting. So it is possible to rescind a resignation, and then we can, slow the process down and see, really what's going on, to really get at the bottom of it and provide some representation.
Mike, we have a question about this, about signing it.
Okay.
Is it, if the district gives you an electronic version of your contract, can they require you to sign it electronically, or can we request a paper to submit without an electronic signature?
The statute doesn't deal with electronic contracts. I mean, it never hurts to ask. I mean, you don't know, what they're going to say. But the statute as written only authorizes and deals with the old, old school written contracts. So I would say there is well, I guess we could argue, well, the statute authorizes a written agreement, and just say, I will stop by wherever and, and pick one up. But that hasn't been challenged, but it, certainly worth giving it a try.
So I think my district does electronic, and what I do when I sign it, I immediately save the document. So I have a copy of what I just signed that I can print for myself. And I make sure that the email that they send to say that they received my signature, I save that email as well. So I have that I signed it and that they received it. Is that what we should all be doing, or am I just paranoid?
Yes and yes. I think
Okay.
no, that's very good advice. Save. It's just, document. Do not trust the school system's email system will have any of this. I mean, it's just good, it's good common sense paranoia. So, so that's good. Anything, oh,
Yep.
now it's forwarding. Let's see. Always read it. Have a contract today from a metro district. New for 22-23 are liquidated damages, and they hadn't seen it before, and through the UNISERV director are looking at, you know, possibilities, what to do. And there's further on in the presentation, we'll get more into it, but if they hadn't read it, they might not have noticed this newest provision relating to liquidated damages. You know, here in Georgia, we've got a hand tied behind our back. I just mentioned this metro district. The contract came out on February 15th. That's about as early as I've heard of. Lisa, have they come out in DeKalb yet, or?
No, but I remember when we did this last year, we did it later and we had members saying they had already received their contracts.
Right. Well,
So, earlier and
bullet
earlier.
Says, there's no law that defines or limits a district's ability to hold the contracts. It does say, well, I'll jump ahead a little bit, that they must be offered by May 15th. But if they want to issue them in January, February, they can. And there's nothing illegal about that. One of the requirements in the contract, it says shall be complete in all terms and conditions, including the amount of compensation for the following school year. And so the question has always been, what do they mean by amount of compensation? And the you know, the plain rubber meets the road difficulty is if contracts are being issued now, the state has not adopted a budget. They hadn't even passed one, correct, Lisa? They hadn't passed a budget for next year. Once it's passed and adopted and signed by the governor, it has to go over to the State Board of Education. They got to approve it and release the salary schedule. And at the same time, your local boards of education have to adopt the budget. So their excuse is, well, when we, you know, offer you contracts in February, we don't know next year's budget. So instead of putting a dollars and cents figure in your contract, we'll say that Mike has worked this many years, he gets this many years credit, and Mike is at this certification level. And based on those two factors, that will be Mike's salary next year. Well, okay, it's kind of hard to argue because the facts, they don't have the budgets completed. That's pretty hard to argue. But once the budget is completed for next year, you have a right to go to the district and have them put in writing what your contract will be for 22-23. So I'd encourage everybody to do that. Oh, and the last bullet, of course, sometimes comes up. Your contract is with the school board, and that means you don't have a contract with a particular school site. So that means sometimes you can be moved to a school you might have been at for 20 years. They could conceivably move you to another school for, you know, I guess a whole variety of reasons. But the point is, your contract is not with a particular school site, even if you've been there for a long, long time, your contract is with the district. So as I said, in education law, in the statute 20-2-211, contracts have to be offered by May 15th for the next school year. Also by May 15th, the superintendent has to provide a notice to those folks that they will not be recommended for a contract for the next school year, 22-23. And occasionally we'll have folks who, are getting anxious. It's, like May 1st and everybody's got their contract. I don't have my contract. Well, there can be reasons for that. The educator might have been placed on a professional development plan and the contract's in a hold somewhere, waiting for some review. But what's very, very clear is that if you don't get the notice, if you don't get a contract by May 15th and you don't get a notice of why you're not getting a contract by May 15th, you have a contract for next year just by operation of law. And that's actually the good news. And that's what that first bullet says. If you don't get notice of non-renewal by May 15th, it's automatically renewed. And they do not have a leg to stand on. They may not like it, but they do not have a leg to stand on. Now we get into a little bit of forecasting here about getting out of a contract, because you see that, if I can move my screen a little bit. If you sign a contract, say today, like in this Metro District, contracts went out February 15th. You can submit a resignation by June 1st to that school district. And they have to honor that. They have to honor that. Now what's also interesting, the PSC goes a little bit further and says that if you submit a resignation prior to June 15th, an extra 2 weeks, the PSC won't sanction the license for a breach of contract. So those are important dates, May 15th, June 1, and June 15th. Those are possible dates that you can submit a resignation and, be on your way and, go on with your plans. Now the law, I throw that in the third bullet is if you receive a notice or a letter from the superintendent that he or she is not offering you a contract for next year, you can ask the reasons why to be put in writing. And I guess I put that in for a couple of reasons. One is a competitor organization capitulated in, 2001, 2002, I think, when Governor Barnes eliminated tenure in Georgia. The competitor said that this language was a compromise. Well, you can eliminate their tenure, but they can request the reasons in writing for the failure to renew the contract. The problem is, for number one, that's an unconscionable thing for any educator organization to do, to settle for a compromise of eliminating your due process rights for a weak statutory token from the legislature, which is pretty meaningless. But if you ask for the reasons in writing, you're giving the district an opportunity to put in every negative thing they ever thought about you into a document which did not exist before. So my advice has always been, it's better to not don't ask them to create a negative writing where one doesn't exist. Because you're not going to have, a remedy to contest those reasons since they eliminated your fair dismissal rights. So, let's see. Well, for those, and it's just a slide, you don't have to spend a lot of time on it. For those folks where fair dismissal has not been waived, these are the procedural rights that you're entitled to under the Fair Dismissal Act. And if the district does not comply with any one of these, and you have GA representation, we can, get your job back for procedural violations that the district didn't follow with. And we could have a kind of a bad set of facts, PDP or an unsatisfactory evaluation. But if the district does not comply with these basic procedural due process requirements, it's game over, and they're required to provide a contract at that point. So what's tenure? I mean, I've used the word a couple times, and I think I've always found it interesting that the word tenure is actually not contained in the Georgia Fair Dismissal Act as it relates to the teachers. Now, I will say, when the legislature took away administrator tenure or tenure for administrators, the word tenure is used. But don't remind them of that. When it relates to teachers and acquiring fair dismissal rights, the word tenure is not even in the statute. But the second bullet there tells you exactly what tenure is here, or how you acquire fair dismissal rights. If you accept the 4th consecutive contract from the same local board of education, you have full due process rights under the Fair Dismissal Act, and that's 20-2-940 sets out some of the procedural requirements of the Fair Dismissal Act. But that's what tenure is. Is any comment about that one? Or
No, but we do have a question that when you apply to a school system, not where you're currently working, there's a question on the application about whether you were offered a contract by the former school system. Is that legal?
Well, short answer is yes. It relates to your professional employment. It doesn't really pry into any private, it doesn't say, like, have you ever filed bankruptcy, or have you ever, doesn't get into, are you married? Are you single? Are you, it doesn't get into any personal matters. But those questions can be really, really tough. Have you ever resigned in lieu of termination or non-renewal? Have you ever been under investigation by, a school district or a certification agency? Those can be tough questions to face. But that one, I mean, not that I'm agreeing with it, but I don't think it's an illegal question. I don't think it's an illegal question. By the way, I just wanted to point out that if someone asks you about tenure, because it's such a loaded word, you should remind folks, number one, we believe in job protections for all citizens. If you work over at the QT, if you work anywhere, we believe in fairness in the employment relationship. And why due process or tenure is important for educators. You know what it's like. You can have a parent march in and say whatever they're gonna say. And here we are entering into an era where we're in a culture war. Georgia's probably gonna have some sort of anti-CRT, am I getting it right? Critical race theory, yeah, CRT.
Anti-honesty in education.
Right. And we're gonna have parents who are gonna be wanting to fire Mike over the way he's talking about, I can teach slavery, but apparently I can't teach how the slaves are being treated. That would make people a little bit too uncomfortable. But seriously, tenure prevents political firings or firings because a parent doesn't like me. If I'm following the curriculum, the whole idea about due process is to prohibit arbitrary and capricious firings and political firings, or personal firings. The principal doesn't like Mike's style in the classroom or what have you. That's why it's important, and it gives you space to be a professional and to feel comfortable that you're not going to be just, out of the blue because the parent over here, the wealthy one or whatever it is, thinks that what you're teaching is harmful to the kids. So that's why we, stand up as we do for fairness in the way you're treated. We know that you have a job with incredible demands from all sections of society, and you really do. You not only deserve it, you really need that protection in order to do a good job.
Mike, we have a question about that. If you leave one school district where you have signed the 4th contract, so you have fair dismissal rights, and you go to another school district, how long in the new district does it take to have your fair dismissal rights in that district?
Yeah, assuming the new district hasn't waived fair dismissal, once you sign the 2nd consecutive contract, you will have established tenure with that 2nd county. And there cannot be any break of employment. That's been litigated. So if I go somewhere for a year and go to another county, I have to sign 4 consecutive contracts
Again.
because there's a break of employment. Okay, well, how do I get out of my contract? Well, 2 basic mechanisms: a release or a resignation. And there's a lot of nuance that'll go into this, but a release is, we don't have a right to a release. That's kind of a stubborn legal fact. It's a grant that is granted by the school district. So it requires it's a mutual thing. I want the release, but it has to be granted. It has to be a mutual act. A resignation, on the other hand, this is where it gets a little nuanced. A resignation, in theory, is a unilateral act. I can resign at any time, but there might be consequences if I do. So, but some people do just say, I've had it, I'm done. It's a unilateral act. They don't have a choice but to accept it. However, there could be some serious consequences for that unilateral act, and we'll get into those. So the PSC, yes, unsurprisingly, you can waive everything but the code of ethics. And the PSC has a rule that if you breach the contract, and we'll see in a slide of what a breach of contract is, they can suspend your license for 90 days. So this is what the PSC considers to be a breach of contract, is when an educator fails to honor signed agreement by resigning in a manner that does not meet the guidelines established by the Georgia PSC. And there's a couple, you can find the guidelines on the PSC's website. If you go there, at the top, there's you can select ethics, and then there's a drop-down menu under ethics, and you want to look at for the resources. You click on resources, and you will find the guidelines for breach of contract. But one of the things that they have said in their guidelines is they won't sanction an educator if they resigned prior to June 15th, and that we're able to work with, a fair number of school districts on that point, because if the PSE, the school districts still use the PSE to do the dirty work, to keep people in line. But the PSE these days is saying, well, if you resign prior to June 15th, they won't sanction your certificate. But oftentimes when you're looking to get out of a contract, common problem is they'd say, well, sure, Mike, we'll let you out, but we have to find a suitable replacement. Now that argument seems to me, it is a stronger argument after June 15th. The closer you get to the start of the new school year, finding a replacement, it can, pose some concern. But if somebody wanted to resign today, finding a suitable replacement it's just not an issue. I mean, we're about like 3 months away from May 15th right now. They've got all kinds of time to find a suitable replacement. So as of today, I wouldn't at all buy into holding up your resignation or request for a release, for that matter, to find a suitable replacement. The facts just don't merit that sort of argument. And you look at, sometimes when you're in this situation, you want to go to a neighboring school district or a school district 1 or 2 counties away, and they have a job offer waiting for you over there. But is that new school district going to accept your resignation, or are they going to insist on a release from your district? Now, and that's usually the big kicker. And let me read to you what the PSE has put in these guidelines for breach of contract, which addresses this. I didn't write this, but it says, it's number 3 on their list of guidelines. Administrators who are offering contracts to educators after June 15th who are currently under contract with another district may have their license sanctioned if the educator does not have a letter of release. So after June 15th, if the new receiving school district doesn't have a release from your current employer, and I'm an administrator, they can come sanction my license, is what this is saying. So it's a legalized form of collusion is how I look at questions like this. You should have more freedom of mobility than you currently have. If the school district next door or 2 counties over is willing to take you, why try and punish the administrator of that school system for, bringing you on as an employee? But anyway, so gets to a common problem when trying to get out of a contract in the new district. Will they accept a resignation, or are they going to require a release? Well, and there's a couple of other pieces that go to your contract, but it's tied into your evaluations. Under the PSE's rule, if you have an unsatisfactory, ineffective, or needs development or the equivalent, that is noted on your license. And then if you have 2 of those unremediated ratings, the preceding 5 years, you're not eligible for certificate renewal. And in either of those cases, you do not advance on the state salary schedule either. And there's no appeal process from these negative consequences on your career. But I know that President Morgan.
Yes, I do have some good news. So House Bill 1295 is going through the legislative process, and actually literally while we were here, I got a message from Joe Fleming, our Director of Government Relations. HB 1295 would take needs development out of this category. So you could still get a needs development, but it would not have adverse action on your certification or your salary advancement. And that bill passed the House Education Committee, but earlier today, it was sent back to the committee. So that is something that GAE is supporting, and we will be at the committee meeting tomorrow to find out why it's coming back to the committee and what we need to do to keep it moving. Mike, we have a question. What does unremediated mean? And the unremediated, where does that come from?
Well, unremediated means that the school district that issued the low ratings have not, had a plan of remediation, like professional development plan that specifically addresses why you were issued that rating in the first place. So I guess the concept is if it hasn't been remediated, then you're still, it's on your record. I mean, that's where it comes from. And, the question is sometimes going to be who's going to do the remediation. If you get, a needs development or an ineffective rating, you should go to them and don't leave it up to the district to, wait till the end of the year or maybe not even remediate the rating. And I know that's tough. You probably feel you don't deserve that rating. And maybe there's ways we can argue that it should be changed. And there are examples of that occurring over the years through our UNISERV directors who informally appeal these ratings and do occasionally get them overturned. But if they aren't, then the next step is, well, show me exactly what I need to do to address the negative rating. And then you got to stay on them. And then once you remediate, make sure, and they show you in writing that that has
I
been
didn't get a chance to check in with all of you today, but I just wanted to be sure I've turned it on.
Make sure that your remediation is communicated to the PSC so that they are aware and it's in their database. Because just because the district is showing it in their records doesn't mean that they ever told the PSC. That's why you need to be persistent and just stay on them until they show you that it's been done in writing. So, well, we're kind of, I guess, winding up on general slides, but I just wanted, this gets into liquidated damages, and GAE is a leader in this area. Filed a lawsuit in 2017-18 against the DeKalb schools on behalf of Chaka Bettis and Leslie Hine, who they resigned prior to May 15th, believe it or not. And the district decided that they go ahead and deduct the liquidated damages from their final paycheck, even though they complied with the state law saying that they had a right to resign actually prior to June 1. But long story short, we went through the litigation. The deposition testimony of the HR director and the superintendent was very revealing, because liquidated damages, the purpose of it is to repair the damage that your resignation did in terms of hiring a replacement. Well, it's always curious. Don't you want to know where the district came up with $750 to make them whole in terms of finding a replacement? Well, in that litigation, they could not do that. They more or less testified under oath, well, they made it up. So, and we had a very good judge, Dax Lopez in DeKalb County, and he found a jury question as to whether or not $750 was a reasonable amount. Well, we know it's not a reasonable amount because they testified that it was just essentially made up. So we ended up settling, and we got all our attorney's fees back. And I want to say they had to repay, the district had to put up a pot of money in the court registry, and folks had to contact the court registry to get their $750 back. And I think it was like a total of $140,000 in the court registry that were able to get these educators their money back. And so our second piece of litigation was against Griffin Spalding School District. Now this is a case a little different. Nikita Jones had a baby. She had a newborn baby who had health conditions that her doctor put in writing that due to her baby's sensitive health conditions, she had to work closer to home than commuting from somewhere in Clayton County down to Griffin Spalding. And the school district ignored it. And she did go on and get her job, but with Clayton, but they took her $750. And Miss Cheryl Clark was, similarly penalized, and she was not getting promotions in Griffin Spalding, but she got a promotional position in Carroll County. Thank you very much for advancing my career, but she resigned, and but they docked her pay $750 in liquidated damages. Well, Griffin Spalding was an unusual situation where the school district, and particularly their attorney, said that GA declared war on Griffin Spalding for standing up for your rights, where I guess it's what you might call a just war. And they said that we were not professional. Well, I guess it takes all kinds in this world. And then lo and behold, they did, we have all the emails to show they took away our payroll deduction because we were standing up for educator rights. And so we actually then had to file a First Amendment lawsuit against Griffin Spalding schools because they were taking our dues deduction away, but nobody else's. And that's a violation of the First Amendment right of free speech. We have a right of free speech to sue school districts. That's part of our rights. And we also have a right of association. We have a right to associate with GAE and to be treated equally like other organizations. Well, that one settled pretty fast. And we do have payroll deduction in Griffin Spalding.
Mike, we have another question and it's back on the fair dismissal. And in the reasons that you can be non-renewed, it has any other good and sufficient cause. Does this mean they really don't need a reason to terminate you or non-renew your contract?
No, I like that question. It means the employee must have done something to cause the non-renewal or termination. There's a good case, it's a GA case that we won on years ago involving APS, and it was a reduction in force. Reduction in force, the employee did nothing to cause the non-renewal. And Atlanta made a fatal pleading error. Their lawyers did, because the only thing they put in the notice of the charges as to why we're non-renewing you is that number 8, any other good and sufficient cause. And we said, oh, holy moly, the employee, teacher, they didn't cause the reduction in force, yeah, we lost the hearing in front of Atlanta School Board, but we appealed it to the state, and the state said, you're right. And so it establishes the principle that any other good and sufficient cause must be something that the employee causes, sets in motion. And it can be a lot of different things. I mean, it can, usually any other good and sufficient cause is put in every charge letter amongst, incompetency, willful neglect of duties, and then they'll throw in the kitchen sink, number 8, any other good and sufficient cause. So that can be any number, wide range of things, but we do know it has to be something that the employee caused.
So something specifically you did
Something
or did not do.
Or did not, that's right. That's right.
Okay, we have another question. If I sign my contract with a K-12 district, and then get offered a full-time position teaching in higher education, is this considered a promotion?
Well, that's a great question. I am looking at the PSC's breach of contract guidelines, and it seems to me there's something here that talks about a promotion. Okay, it's number 7 on the guidelines for breach of contract. After June 15th, the PSC will not sanction a certificate if the educator left for one of the following reasons. C, a promotion within the field of education. A promotion must meet each of the following criteria: an increase of job responsibility. So it sounds like higher ed might be that. Increase in prestige. Well, I guess I might argue with that one, because K-12, that's high prestige. I mean, I'm serious, and they probably fuss over that, but increase in prestige, and an appropriate and reasonable increase in salary.
Okay.
So you could meet 2 of those 3, and you could argue that it's higher ed is more prestige, and you just might find yourself getting it. What it usually gets to, though, is that salary component. So if it definitely meets the promotion or you're in the field of education, you probably have more job responsibilities. Is it more prestigious? That could be debatable, but the salary is usually that has hung up people in the past.
And next question. I have a question about the jargon used in the teaching contract. other duties as assigned. What exactly can this encompass?
What? Well, it encompasses quite a few things. Well, I guess it can get to, and to put a little exaggeration on it just to get the discussion, they can tell you to do just about anything except put a new roof on the school or put new asphalt in the parking lot. Those would be unreasonable conditions, but other duties as assigned, you always read into their other reasonable duties. Always, never forget that. They don't put that in there. They just say other duties as assigned, but you put in their other reasonable duties. So that's an intentionally vague term, but it gives us something to work with. What's an unreasonable duty? Is it showing up before my appointed time to do bus duty, or to stay a little later for bus duty? Or, you know, the list can go on. Is it other duties as assigned? You're taking away my planning to cover for somebody else's class. Is that unreasonable? And in a reasonableness analysis, what courts are going to look at, I suppose it would be the nature of the duty and the severity, or how many times are they asking me to perform this duty? Is it once a week, once a month, or is it every day? And then that actually bleeds into a question of compensation. There's a metro district in Gwinnett. I was surprised they have a policy that says the workday is 8 hours. I was kind of bowled over with that. You usually don't see a policy that says it's 8 hours, but you have to read into their other reasonable duties. But at least you have a baseline to argue from. Their policy says 8 hours. So the question for a group of folks in Gwinnett is, I think it revolves around this bus duty question, where they're showing up early, you know, mandatory duty, got to do it, or there's a consequence. It's longer than 8 hours. Are you going to pay me? What are you going to compensate me for? So I like that question, and it never forget it's a reasonable duty. And then, of course, again, the question is, given that intentionally vague legal term, how many times does it take for it to be unreasonable? And there's no bright line answer to that. There's just no way to really tell you in advance what that's going to be. You know, if they're telling you, there's a clearer answer, I think, in my mind, if your contract says 190 days, for example. In my mind, that doesn't include summer, and it doesn't include weekends. It, to me, probably doesn't include taking tickets at the football game or the basketball game, or working the prom, working the concession stand. I mean, you know, we can go down that list, that's beyond the workday. It's just not reasonable for me to volunteer my family time to work for the district for zero compensation. So there are various ways to approach that, principally by organizing at the local level, getting folks together to have the principal of the school district to adopt a fair and equitable policy as to what the expectations are. And, you know, if I'm going to be taking tickets at the football game, am I going to get something in return, like something like a, you know, early release date, or you know, something, at least recognition. I think a lot of times these kinds of issues boil down to respect, recognition as to who you are as a professional, and respect for what you do. And those questions can really be addressed by, going to your board meetings in a group, get your colleagues to go, put on, spend a few dollars and everybody wear the same t-shirt with your local's name on it, work with a UNISERV director, sign up to speak at board meetings, and just keep at it, be persistent with it. And you can affect change through persistent organizing and attending school board meetings.
Okay. Mike, I think that's our questions, and we've gone over a little bit, but
Mhm.
I think everybody learned a lot. And we know GAE Legal is still here for us. Any other questions from our attendees? If not, thank you all for joining us this evening, and thank you, Mike, for all the information. And we will be posting the recording, and I will send a link to the recording to everyone who registered. It will probably be Friday before I am able to do that. Tomorrow, there are committee meetings at the Capitol all day. And then those of you who are registered know that Thursday is our GAE day at the Capitol. So thank you all for joining us this evening, and you all have a great evening.